Good morning, viewers. Today we bring you another episode which will be related to wills. And we have our expert, Mrs. Sushila Varma, Chief Consultant. So we are going to have a brief Q&A regarding wills.
Thank you, Arjav. And I think the team has chosen a good topic again. It's of great relevance for a lot of people.
So my first question to you, ma'am, is what is a will and what is the importance of making a will?
Now, answering your query as to what is a will is the last intention of a person. The person is known as the testator. So, I would say it's the last intention of the testator as to how his estate or property has to be distributed. It is not necessary that the will have a distribution of the assets only to legal heirs. It could be any third party whom the testator has decided to give the properties. The significance of a will is that the testator has already decided how the property is going to be distributed. Hence, it avoids a lot of confusion or it avoids a lot of animosity in a family. Over and above that, if there is a will, then the property is not deemed to be abandoned and does not revert back to the government but gets distributed to the parties who are named as beneficiaries in the will.
Thank you, ma'am, for answering that. So my next question is who is eligible to make a will in India?
The answer is very simple to your second question. Any person who has attained majority can make a will. Also, the person who makes a will must be of sound mind. That is, at the time when he's making the will, he should not be intoxicated or he should not be afflicted by some illness that does not allow him to think clearly. So, these are the only two requirements for making a will.
So, ma'am, can you tell us, is there any law or enactment which governs the laws relating to wills?
The general law that applies to wills is the Indian Succession Act 1925. It applies to Hindus, Sikhs, Jains, Buddhists, etc. However, there are certain personal laws such as the Hindu law, the Muslim law. These can also be applicable to the person who is making a will. So it is not as if one is only bound by the Indian Succession Act. One can also look at provisions of the personal law.
Very well said, ma'am. So, coming to our next question, it is how can a will be revoked?
Now, answering your question as to how a will can be revoked, it's very simple. First, you could destroy the will. Second, you could make another will which will automatically revoke the first will. And third, you could make a declaration that any intention you have expressed in an earlier will is deemed to be void.
Thank you, ma'am, for answering that. So, my next question would be when can a will be challenged and who can challenge a will?
I would say a will can be challenged for four reasons. Improper execution of the will. If the will is uncertain and it is not clear as to what was the last intention of the testator. If the will has been colored by fraud, coercion, or undue influence. And lastly, if the person who made the will did not have the capacity, that is, he was not a major or he was not of sound mind and could have made a will. Now, coming to the part as to who can challenge a will can be challenged by any of the legal heirs, whether they are named in the will or not named in the will. Apart from that, there could be a category of people who feel that they would be or they could have been prospective beneficiaries but have not been named in the will. And if they have a proper ground, they can certainly challenge the will and explain to the court as to why they feel they should have been included in the will but were excluded from it.
My next basic question to you would be should a will be registered and what are the benefits of getting a will registered?
I would say registration of a will is a must. A will is an extremely important document and there are times that one can misplace a will. So if the will is registered, one always has the option of getting a copy from the office of the registrar. Over and above that, a registered will gives confidence to the heirs that the will is genuine. Lastly, it reduces the disputes that can arise or have arisen between the legal heirs and beneficiaries that may be there. Now, what happens when you go for registration of a will is that the registrar asks the testator whether he has made up his mind, whether the properties that he has mentioned in the will belong to the testator. The registrar checks with the witnesses. He understands from the witnesses whether they saw the testator sign the document. And then, after having satisfied himself of all these conditions, the will is registered. Hence, I would say it's an extremely important document, because once the testator is dead and gone, it is only the will that will speak for the testator and no other document can replace it. A will is executed after the death of a testator by any of the named legal heirs or beneficiaries in the will. It is generally taken to a court of law and a probate is applied for. This is the job of the executor who is named in the will. An executor is a person who has enjoyed the trust and confidence of the testator. What the testator does is puts a duty on the executor to ensure that his last wishes are carried out completely. An executor not only looks at the assets but is also responsible for the liabilities. So when a person passes away, the executor takes charge of the entire estate of the deceased, and then he first clears all the liabilities that the deceased may have had, like taxes and other dues that he may have had to pay. And after clearing all the dues, he then distributes the assets as per the wish and intention of the deceased.
Then, coming to our next question, after the definition of executor, can we know, ma'am, who is an administrator?
An administrator is a competent person appointed by a court of law who looks into the assets and liabilities of the deceased. This generally happens when the deceased fails to leave a will. Once the administrator takes over the property, he first does away with all the liabilities of the deceased, and whatever assets are left, those are then distributed amongst the legal heirs.
So, we quickly jump to our next important topic, which is related to probate. So, ma'am, can you tell us when does one apply for a probate?
One applies for a probate when there is a will. What the court does when you apply for probate is puts a stamp of approval of the genuineness of a will. Once this is done, then the executor can take over the assets and liabilities of the deceased and fulfill his duties as an executor.
Very well answered, ma'am. Also, can you tell us when does one apply for letters of administration?
Now, answering your query, it is when the deceased dies without leaving a will, that is, he dies intestate. But it's not only in these conditions, it is also possible that an executor has been appointed and the executor is incapable of executing the will for whatever reason, ill health, or he does not have the time, etc. Then, in such a case, a reliable person will approach the court and ask to be granted to be an administrator for the estate of the deceased person.
So, coming to our last question, what is a succession certificate and when does one apply for it?
A succession certificate is a certificate granted by a court of law, which in this case is generally the district court, in which the judge recognizes the right of persons to inherit the assets or liabilities of the deceased. There are certain documents that are required while applying for a succession certificate. These can be seen on the screen below. A succession certificate is a must when one is trying to inherit, say, a bank account or a fixed deposit or an insurance policy, etc. Now, let me answer a very important question for all viewers. Can the court set aside a will? Generally, the answer is in the negative. A court does not want to interfere in the will because the testator who wrote the will is dead and gone. But a court can interfere if they feel that a will is not genuine. In a recent Supreme Court judgment 2023, Dhaniram through LRs versus Shiv Singh, the court was of the opinion that the will was not genuine because the testator's signatures were not the same in all the pages. The witnesses did not sign at the same place where they were supposed to sign, and hence the court felt that there were conditions which led them to believe that the will was not genuine. But what the court said in this matter is extremely important. The court was of the opinion that it is always better to annex a doctor's certificate which will establish the mental and physical well-being of the testator at the time of making the will. Apart from that, the court also felt that if a video recording is made when the testator is signing the will, it would go a long way in helping the beneficiaries and the legal heirs to prove that the will is genuine. Viewers, I would request you to please treat this episode as a legal tip only and not as legal advice. The law on intestacy and wills is a very complex law, and each advice will depend on the facts and circumstances of the case. I would therefore request you, if you have any queries, please reach out to us or reach out to any lawyer regarding what should be the next steps when it comes to wills. If you have liked this video, please like, share and subscribe so that you can encourage us to produce many such videos in the interest of the general public. Thank you and Namaste.